So we'll go for Contract Act. Able to see?
Yes, sir.
So yeah, I am not having the BEAR Act. Okay, so BEAR Act first page you will know when it is enacted. So it governs all agreements and contracts in India. Contract Act. So it is to enforce right and duties arising from agreements. Okay, so main sections are 1 to 75, where we talk about say what exactly is the general principles of contract. There are actually there are other Sale of Goods Act. All those things were part of Partnership Act was part of Contract Act only. So they have removed those things and made separate acts. Actually, earlier there were more acts. So you will find gap in between that sections. I am not carrying the Contract Act, BEAR Act actually with me. I would have told you exact what are the acts included in Contract Act. Okay, which sections. So I don't want to give wrong sections to you. And one more thing, just I'll before just I'm opening my this thing notes. I'll just open the paper. I'll see if I have missed anything in the thoughts. See, tortfeasor is one important topic I missed out. Tortfeasor is a person who is committing wrong. Okay, we call him tortfeasor. Okay, tortfeasor. This is important concept. Joint tortfeasor is more than one person is committing that one. It is joint tortfeasor. Okay. So UB just EB remedium we have sign is without or okay without that is sign damnum sign injuria damages without injury. Okay, remedies compensation no punishment. Okay, this one we have completed. Trespass assault battery we have completed. Nuisance completed. Defamation negligence. Okay, so res ispa loquitur. This is another this thing. Res ipsa loquitur. Okay. So actions speak for itself. The term, okay, this is applicable in road accident cases and medical negligence cases. Things speak for itself or action speaks for itself. Res ipsa loquitur. Okay. So another thing is lost opportunity is also one time they have given this case, that is contributory negligence. Okay, last opportunity we spoke about this. Actually, I have given some example. So last chance is the thing. So when you are driving a vehicle, so even if you are having a small opportunity in the last movement, so you are not wrong. The other person is coming, somebody is coming. That's what I told. If one thing I told you, right? So even if there is no mistake, you have to pay compensation. Okay, same thing. This is contributory negligence, they call it. Somebody is coming in the opposite direction. You are going in the correct direction, and he is coming in the wrong way without headlights, whatever it is. But you notice in the last moment, if you have an opportunity to avoid that accident, even in the last 1 or 2 seconds, you should do that. If you, after seeing that also, you are committing that accident, that is contributing negligence. Last opportunity or last chance is applicable here. That is contributory negligence or last opportunity, where in the last few seconds, 1 or 2 seconds, you are committing that mistake. Lot of animals you commit. One case is there, Davis versus Munn. Okay. So Davis versus Munn, a vehicle, speeding vehicle kills a donkey. Donkey suddenly came running on the road. So Davis versus Munn, that in that case, Munn has to pay that damages. Okay. So okay, Danog versus Stevenson. I told you that one case, right? That is, there was a snail in a beer bottle. Okay, there was a snail in the beer bottle. So manufacturer should take that responsibility. That is the thing. Okay. So Bhopal gas compensation case is Charan Lal Sahu versus Union of India. So okay, these are the things. So we have, I think, taken all the things, covered everything important point. There, see, thought is very huge. Okay, so we try to cover all those things. So when you are solving previous year question papers, whenever you come across thought related questions, and if you feel that, I'll try to give some case laws also, so that thought related, and you get case laws for environmental case laws, MC Mehta. It is both actually, environmental versus torts also. So you get such case laws. So I'll try to give some case laws. I think already few people shared in the group. So you can go through the case laws and concepts. So whenever you find some concept like what I told, damages without injury, damnum some injuria. So those things, if you find something new, try to note down. Google it, note it down, and read that concepts. That is the only way, because it is very difficult to cover everything. We have to do like what we do in colleges, 40 classes, 50 classes per subject. Okay, so that is the thing. So this is the so meaning of a contract: an agreement enforceable by law is a contract. Very simple. Section 2H, you can find it in the definition. They will ask what is contract. They will give Q3 alternative: agreement plus legal enforceability. They will give this. They will give certain combinations. So you have to remember this thing. So any agreement which is enforceable by law, in agreement. See, I will talk about agreement later. Any agreement, okay, enforceable by law is contract. So enforceability is important. Example I have given here. A promises to sell his bike to B for 20,000. B agrees. That is a contract. A promises to meet B for lunch. Okay, this is an agreement, but it is not enforceable by law. Okay, social get-togethers, those things are not enforceable. So, which is enforceable by law is a contract. Which is not enforceable by law is agreement. Any give and take between two people is agreement, but if it is enforceable by law is contract. So agreement is, again, there should be an offer, there should be an acceptance. You are giving something and other person is accepting it. Okay, so but it should be enforceable by law, then it is a contract. Offer plus acceptance. Okay, agreement plus legal enforceability, they may ask anything. Agreement plus legal enforceability, acceptance plus agreement, whatever it may be, they will ask multiple combinations. So you understand this very properly. Contract is agreement and legal enforceability. Agreement is offer plus acceptance. There should be an offer, there should be an acceptance between two people at least. So what are the essential? This is section 10 is very important. Okay, in Contract Act, it will be there in the Contract Act. You have to carry the Contract Act book along with you. Offer and acceptance, free consent. Okay, this is conflict based, no coercion, undue influence, fraud, misrepresentation, mistake. These things you will get subject related questions also. Okay, then competent parties, major, sound mind, not disqualified. These things there will be case laws. Okay, Dharmodas Ghosh versus Mohri Bibi, some cases are there. Okay, if there is some case, I will try to give in the case laws. Okay, minor case in that it is related to some minor Dharmodas Ghosh versus Mohri Bibi and Gauri Datta. Those cases are there. Balfour versus Balfour, and then if there is anything specific, I'll come to that separately. Okay. So what are essentials of a valid contract? Offer should be there. There should be acceptance. There should be free consent. Free consent means there should not be any coercion. Coercion means threat, force. There should not be anything. There should not be undue influence. somebody is forcing, like teacher is saying something. Okay, I am telling you something as a influencer. Okay, so if an influencer is saying something, it is undue influence. I mean, if he's giving correct advice, that is different. Undue influence is you misusing his influence. Okay, then fraud, misrepresentation, and mistake also. If by mistake somebody is agreeing, then it is not a free consent. If by you are telling something wrong and he is agreeing, believing in you, it is misrepresentation, then it is also wrong. Fraud, intentionally you are doing something, it is a fraud. Undue influences, because your father, your mother, your husband, you are telling something to do, your wife, it is undue influences. Coercion is putting something to sign on gunpoint, is a coercion. Okay, then competent parties. So the parties to the agreement should be competent. I mean, they should be major above 18 years, sound mind. I mean, they should not be drunken or unsound mind like pitchol. Let us say that word. Okay, mentally unstable. Then not disqualified by law. Not disqualified by law in the country. So some people are disqualified to do this. So they should not be disqualified by any law. Then lawful consideration. Consideration means something in return. So there should be lawful consideration. You are selling something. I am selling you a pen. You are paying me 10 rupees. So that is consideration. I am giving you the pen. For you, pen is the consideration. For me, money is the consideration. Okay, you are paying money and you are taking the pen. That is the consideration. For me, I am giving you the pen. Taking the money is the consideration. Lawful object. The object of the contract should be lawful. You cannot say that we will enter a contract to smuggle illicit liquor, we will smuggle some drugs. Okay, the object should be lawful. I mean, in the country, it should be lawful. Otherwise, it will not be a valid contract. Not expressly declared void. Okay, so if some contracts expressly they are declared void, in those cases also, it is not a valid contract. Then legal intention to create obligation. There should be intention. Okay. Then only it will be a contract. So offer, proposal. There should be an offer, that is proposal. Then there should be an acceptance. Offer means that I am giving you something. Acceptance means I am ready to take this one. So offer to a particular person to public a law. Okay, this is very important. Carlyle versus carbolic smoke ball. Okay, Carlyle versus carbolic smoke ball. This is the general offer. Okay, general offer is also part of a contract. So here Carlyle is a person, carbolic smoke ball is a company. Smoke ball ante manam oka chinna pipe పెట్టుకొని ఏదో దాన్ని ఏమంటాము హుక్కా లాంటిది ఒక రకమైన let us take it is similar like hookah. Okay, smoke ball where that they give that smoke ball, they will put it in the hookah, they can take that smoke. Okay, smoke ball, carbolic smoke ball is the company. So carbolic smoke ball advertises that if they take their smoke ball, some they will there won't be some nothing will happen, something like that, or cold will be cured, something like that. Okay, cold will be cured or nothing will happen. I think cold will be cured if they take their smoke ball. So Carlyle tried, they have advertised that, and if cold is not cured, they will pay $1,000. That is the thing. So anybody can try this Carlyle smoke balls. If the cold is not cured, they will pay $1,000. So Carlyle tried, his cold is not cured, so he filed the case that as per their advertisement, I tried the smoke ball and my cold is not cured, so they had to pay me $1,000. Then carbolic smoke ball told, no, there is no offer. Offer is there, but there is no physical acceptance from Carlyle. You should have accepted that I am trying your smoke ball. Then we would have. But here it is general offer, need not be accepted. By doing that specific act, smoking that smoke ball is acceptance. So general offer is also, you can find the case law. I just try to explain this case law. I don't know exact content, but this is a broad because I read it long back. I don't. And let me tell you, with this carbolic smoke ball, I read it in 1991, if I remember. After that, I didn't remember, but I still remember that small story. So I am able to tell you the same thing, Carlyle versus carbolic smoke ball. 1991 for my CA, we have subject for contract act. So I was doing that. 1 minute. So then termination, rejection, lapse of time, death, counter offer. This is the thing. Acceptance is the person is accepting that. Okay. But absolute conditional. There should not be conditional acceptance. It should be very clear and it should be communicated also. Offer should be communicated. Acceptance also should be communicated. Okay. And it should be communicated before the offer lapses. Okay. You will say that I am giving an offer to sell this car for 1 lakh rupees. So if anybody gives their acceptance before 5 o'clock today, I sell this for 1 lakh rupees. And after that, it will be 1.5 lakh rupees. So if somebody comes before the time, then it is okay. But if the time lapses, the offer is also lapsed. So you cannot say that your offer is there, so I have communicated to you, but you received it late. No. Communication of offer and acceptance. So communication of offer and acceptance. So when it comes to the knowledge of the offeree, offeree is who is nothing but acceptor, the person to whom you are offering. So when it is completed, so the communication offer should be completed when it comes to the knowledge of the offeree, that is acceptors. So see, this may not be so important these days. It was important in old days when the communication was done through post and other ways of things. It used to take 1 month, 2 months, 3 months to communicate some things. Okay. So they used to use postal, all those things. So if the letter of acceptance is posted, communication of accepted. So when the letter is posted, you are accepted. Even the offerer, say the person who is offering say, no, I haven't received that letter on time. No. If the person is posting the letter, that acceptance is cleared, completed. So by email, it is okay. Revocation is very important, but I don't know whether you will get a question or not. Offer can be revoked before acceptance is completed as against offerer. Okay. So it is offer can be revoked before acceptance is completed against offer. So here letter of acceptance is posted. So that is completed against the offeree. So offeree is completed his duty, but he can cancel that acceptance before that offer reaches the offeree. So offerer is offering. A is offering to sell something to B. So B received that offer. He wrote a letter. Okay, I'm accepting to this, and he posted that. So now A cannot cancel that because B has posted that. A cannot cancel after A posts it. He can cancel before B posts that letter. Once the B posts it, A cannot cancel that. But B can cancel that acceptance before that letter reaches A, and he should communicate in some way that before that letter reaches, he should communicate that I have accepted that. Now I am not accepting that. I am revoking that acceptance. So that is the cancellation. Okay. Offer can be revoked before acceptance. So they may ask such question like, case law sort of thing, whether it is accepted against this person, that person. So I'm explaining this. Acceptance can be revoked before it reaches the offerer. I gave that example, so I think it should be clear for you. So consideration means something in return. So I'm selling you the pen, you are paying me the 10 rupees, that is something in return. Okay. Something in return means consideration means simple. Don't remember anything, something in return. That is only meaning. So completion and performance of contract when both parties fulfill their obligations. So I gave you the pen, you paid me 10 rupees. Okay, you paid me money, I gave you, sold you the house, whatever it is. So contract will be completed. Okay, breach of contract. So what is breach? So failure from anyone. It can be offerer or the acceptor. If there is a failure to perform their contractual obligation, then you have remedies. Okay. So what are the remedies? Damages, that is compensation. Specific performance. Okay, specific performance is part of Contracts Act, actually, big thing, actually, specific performance. So specific performance is purely related. We find a lot of specific performance related cases. This is related to contract, where contract is not performed, then there will be specific performance. Okay, so specific performance, then injunctions. Okay, quantum merit, then rescission. Okay, this is the I try to cover the maximum this thing.